Effective January 21st, 2026, the U.S. Department of State has indefinitely paused the issuance of certain immigrant visas for nationals of 75 countries identified as posing a risk of high public benefits usage. This policy affects family-sponsored, employment-based, and diversity visas processed abroad, but does not impact non-immigrant visas like student visas or tourist visas. Let me clarify something very important. This is not a ban. No immigration laws have changed. No employment-based categories have been eliminated. No I-140 petitions are being canceled. What has changed is procedural, and it affects how immigrant visas are issued at U.S. consulates abroad. If you're applying for a visa based on an approved petition from outside of the United States, this is what you need to understand. In this video, I'll explain what has not changed, what has changed, who is actually affected, and how to prepare strategically. I want to start with some reassurance. You can still file your petition. It can still be approved by USCIS. You can still submit your DS-260 immigrant visa application. You can be scheduled for an immigrant visa interview, attend your interview. None of that has changed. USCIS is still adjudicating employment-based and family-based petitions. The immigrant visa system is still operating. It's not a total shutdown. Now let's talk about what has changed. This shift happens after the interview stage. In certain cases involving nationals from 75 countries, visa issuance may be paused for additional review. And this language matters. It's paused, not denied. Although it is an indefinite pause, we don't know when it's going to be lifted. It's not a full rejection, it is an additional review. Administrative processing has always existed. What we're seeing now is extremely heightened scrutiny in certain cases. This is a major procedural delay to have the same effect of a legal bar, but we're expecting it not to last forever. We just don't know when it's going to be lifted. Let's talk about what is being evaluated. The primary issue being examined is public charge risk. Let me explain that calmly. Public charge refers to reliance on government financial assistance. This review has always existed in immigrant visa processing, and immigrants are highly unlikely to depend on government assistance. So what has changed is the level of scrutiny for certain passport holders. The burden to demonstrate financial independence may be applied more strictly. Now here's the important reframing. Many employment-based applicants, particularly high-skilled professionals, are often very well positioned to demonstrate national interest exceptions to this pause. EB-1A and EB-2 NIW applicants typically have advanced degrees, strong career trajectories, have documented income or job offers, possess high-value professional skills. In many cases, this places them in a stronger position than other immigrant categories. So while scrutiny has increased, it is important to see what exceptions may apply to your case. Think of this as a passport-based rule. This is critical because the pause depends on the person's nationality, not the physical location of the consulate. It is nationality-based, not embassy-based. That distinction matters. If someone holds dual nationality, the person may be able to apply using a passport that is not subject to heightened scrutiny. Strategic planning must happen before filing. This is not something to evaluate after your interview. If you hold dual nationality or you're subject to the visa pause, you may have a solution. You can request a free case evaluation below so we can assess the strongest path for your situation. Now let's talk about who is not affected, even if they are from those 75 countries. This is equally important. The following are not affected by this procedural pause: non-immigrant visas such as O1s, H1Bs, and tourist visas, adjustment of status applications filed inside of the United States, immigrant visas that have already been issued prior to January 21st, 2026. If you're inside the United States filing adjustment of status, this does not stop you from filing your 485. If you already received your visa, this does not cancel it. So let's break all of this down really clearly. If you're outside the US, prepare your documents according to US Embassy instructions. Expect the possibility of administrative pause. Do not assume rejection. Be patient but proactive. If you are inside the United States, this does not stop an I-140 or an I-130 from being filed. Monitor the visa bulletin. Consider adjustment of status if you're eligible. The key here is preparation, not panic. All of these different immigration headlines and happenings can sound dramatic and, quite frankly, scary. But what truly matters is understanding how your individual case will be evaluated. If you're pursuing a high-skill visa or considering whether your profile is strong enough, I recommend watching my next video. It will help you understand what USCIS is actually looking for and how to position your case strategically. See you there.